session before this, we heard a lot about the guidelines for the electoral reforms. In this panel, we're going to see how they are applied or maybe not applied in different case studies. We have 4 individual case studies on countries Poland, Nigeria, Lithuania, and Spain. And then we have a paper that's looking more broadly at the European Parliament elections and what lessons were learned there. So without further ado, because of the time, I'm going to give the floor to our first speaker, Anna Frydrych-Depka, which is going to talk to us about the Polish electoral code. Anna.
Hello, everyone. Thank you very much. I'm very honored to be here today with you. I was very inspired by the previous panel, and I will try to take a look inside what's going on in Poland if it comes to the electoral reform. The title of my presentation is Polish Electoral Code in the years 2011-2024. Was it an evidence-based reform? But I couldn't start without saying that I was inspired that the consensus is so important. Of course, it's quite obvious for all of us which deal with elections. And I have to say that unfortunately in Poland, we are in the situation of a dissensus, more likely. Like next year, we will have a workshop, academics with the civil society, what we can do about the dissensus in our politics and how to deal with this. And of course, in terms of electoral reform, it's also very important. What is the field of my study? First of all, apart from the Constitution of 2nd April 1997, the legal act regulating electoral matters in Poland is primarily the Electoral Code, so the act of the 5th January 2011. In Polish doctrine, the term code is understood as a legal act that comprehensively regulates a specific area or branch of law. The adoption of this form of regulation is important for several reasons. Firstly, because electoral law is a broad field, dealing with very important citizen political rights, enabling the exercise of power through voting. Secondly, this form of regulation is quite widely recognized as ensuring the stability of norms or even increasing resistance to the instrumentalization of electoral law. Our code was promulgated on the 31st of January 2011 and came into force after 6 months. Unfortunately, after this 13 years, I cannot say that this hopes for the stability and the lack of instrumentalization is in place right now. What was important for me while projecting this study? First of all, I'm looking into only the legal type of reform. I'm a legal scientist, and so first of all, the most important for me is the electoral code. And if it comes to the legal phase, it's like we haven't got any constitutional reform in the years 2011-2024. That's why I'm looking only on the electoral code. In which aspects? I'm trying to answer the question, was the reforms that took place informed by evidence? Were they credible and high quality sources of evidence? And what was the time frame? Because the first point of this study for me was the stability of the electoral law. The main subject for me, which I was studying, were the explanatory memoranda to the draft laws. Secondly, I also look into the proceedings of the commissions and subcommissions, committees or parliamentary committees and subcommittees dealing with the drafts reforming or amending the electoral code, and further going the internal and external opinions, which in Poland are mainly legal ones, in this field. Next slide. What are my research questions, which I think I have answered? Is the Polish electoral reform in legal terms based on evidence? And are the proposals well documented? On what sources of evidence are the project based? And which sources are the most influential? And I have to admit that this last question is quite interesting for me because I'm also an observer. I'm working with the Political Accountability Foundation in Poland. We are the member of GNDEM and as well the NMO. So we know GNSA, and we are very happy that we can contribute somehow. We are trying to fight for a good electoral reform of our electoral code, and we are doing our best, but this is not the topic of today's presentations. What are the main data, the basic data concerning this year's electoral code in Poland? Over the 13 years it has been in force. 34 laws have amended it, and a total of 540 singular amendments. In the terms of singular amendment, I'm considering like amending a norm of the electoral code. Yeah, a single amendment. Of course, these were changes of a different nature. Some of them, they were only unifying terminology within the legal system. But what is noteworthy is that of the 11 acts introducing a minimum of 5 amendments to the EC, all of them entered into force in the election year. So this time frame is quite a red flag in our case. Only one case, counting from the date of entry into force, was there a period of 6 months of legislative silence before the election was ordered. And the 6-month period of legislative silence is something we derive from our constitutional tribunal interpretations and opinions. Most often, amendments entered into force with a vacatio legis of about 14 days. And one time it was quite longer, but it was in favor for political parties because the amendments concern their obligation to make publicly available records of their contributions and contracts. And then it was 7 months. On the other hand, in the view of expectation of maintaining the highest legislative standards, as well as counting on an appropriate process of opinion and consultation within the experts and civil society, one should look at the time that elapsed between the submission of the bill and its promulgation. And here it is also quite a red flag. You can see on the slide, from the 34 amending laws, only 7 took more than 6 months. The process of amending from the beginning till the entering into force. 15 took more than 3 months, but less than 6 months. And 10 took less or just over a month in total. And the shortest procedure of EC amendment took only 5 days. Maybe it's somehow understandable because it was the first COVID shield and the regulations, the provisions were very important for the universal suffrage because they entitled voters to use alternative voting methods, especially those voters who were in quarantine and in home isolation could use the postal voting. What is very important, because after seeing this basic statistic data, I started to wonder, like, why is it like that? Okay, we had like 14 elections during that time. So maybe we are so keen on improving that after each electoral cycle, we know what is to be improved and we are implementing that. Here you can see, like, we had 4 times the elections to the Sejm and Senate, so our parliament. 4 times we have elected president. 1 time in 2020, unfortunately, we didn't go to the voting stage, and we had to deal with the process another time. In the same year, 3 times we had local elections, and 3 times we had elections to the European Parliament. And the frequency of the amendments, as well as the timing, and both the adoption of the amendments and their proceedings may raise concerns about the instability of the Polish electoral law. So I was trying to check what were the reasons. Were they reasonable? And I was looking for the sources of evidence. First of all, I gathered them in my mind. What could be the best sources of evidence for electoral reform? And of course, these are the observation reports, as well as the international one, as well as the domestic ones. And we are the part of the Council of Europe, and the Venice Commission opinions should be important for us, and we do try to implement the recommendations of the Code of Good Practice in Electoral Matters. If it comes to a domestic observation, we have it since 2018 in our electoral code, so the domestic reports weren't the source from the beginning of the entering into force of our code. If it comes to audio reports, we have 4 final reports, mainly concerning parliamentary elections, but unfortunately more than 60 recommendations is still pending, and only less than 20 was implemented, not all of them fully. The most important for me source of evidence is the information on the implementation of the provision of the Electoral Code and possible proposals for its amendment. It's an institution of the Electoral Code, and it's the obligation of the task and the duty of the National Electoral Commission to submit to the President, Speaker of the Sejm, and the Speaker of the Senate, and the Prime Minister after each election this kind of information.
Anna, and one more minute.
Oh, wow. These informations are very, very important. Why? Because they are mainly evidence-based. And are they implemented in, and are they used in our electoral reform? Unfortunately, no. But what I was curious about, because in 2018 we had like very important changes if it comes to the composition of the National Electoral Commission. And we are now saying that the commission is politicized because 7 members are picked by the Sejm, and unfortunately the level of the trust to our National Electoral Commission has lowered. And since 2018, the influence of the information of the NEC has increased. Here on the slide you can see the answers for my questions, and unfortunately the main answer is that our electoral reform is rather not based on evidence. I was trying to avoid this legalish term, it depends. But what I would like to recommend, even that the red flags are here in my country, I do think that this institution, that the highest electoral body is in power to submit after each cycle the information about what could be improved, is a very good regulation. And I think we should be happy that we have it in our electoral code. But if you would like to use it, please think about what is the state of your EMB. Is your EMB in the capacity to collect data? And are the data collected by the EMB provable and useful? And of course, do you have a high level of trust in your EMB? And what I would try to recommend also is that you can consider if this kind of instrument should be mandatory to consider the proposed amendments. And in my opinion, from the legal point of view, it cannot be obligatory or mandatory, but maybe in the regulation, it can be stated like that the parliament or a committee or a subcommittee of the parliament, if it's not taking into consideration the amendments proposed by the National Electoral Commission, for example, in their information, then the committee, subcommittee, or the whole parliament should justify why they did not include it. And with that, thank you for 1 more minute, I think. I will.
No, you really have to wrap it up now.
Yeah, I am. I'm
Thank you.
more than glad to answer the question in the discussion. Thank you very much.
Thank you very much, Anna. Sorry to have to rush you, but we are moving quickly on to our next presenter, Edward Agbai from Emmanuel University in the USA, who's presenting on the Redesigning Elections for Democratic Integrity, a case study of Nigeria. The floor is yours, Edward.
Thank you. I will just put my stopwatch. Thank you. So thank you very much. I will just go that first is that I was an advisor to the presidential candidate in the 2023 elections. That led us to do a book about the 2023 elections in Nigeria, actors, winners, and intrigues. And that is on Amazon. I also contested for elections in Canada last year in Saskatoon. I'm the director of Prairie Africa, executive director. I'm also managing a consulting company. I've authored and co-authored some books and some peer review articles. So about the electoral reforms, which I'll go straight to. Why do we need electoral reforms? Especially in the case of Nigeria, which is the case study I'm trying to, because it makes for more democratic, inclusive, and transparent electoral process. And it helps to address, in the case of Nigeria, voters' apathy. In the Nigerian context, there have been 7 electoral cycles between 1999 and 2023. We've also seen that there have been voter suppression, electoral violence, and voter apathy within the elections. And that has given rise to the late President Yar'Adua constituting the Justice Owei's report in 2007. Also, there have been some technological advancement that have come in 2015 through the smart card reader that made that there was a change. An incumbent lost the election. So technology is a good thing. If you look at the slide I have here, you can see that on your left, while voters register has increased, voters participation has reduced. It has increased from 60,000 in 1999, 60 million rather, to 93 million in 2023. But it has reduced from 30 million to a little about 23 million in 2023 from 1999. Also, the percentage has dropped, percentage of participation in the voter process has dropped from 50%, it has dropped to something like 20-something. Also, every electoral cycle, you see that there's a drop in averaging about negative 10% in the electoral cycle. So we underpinned our research on three broad reforms, which are what principles should underpin the electoral reform process? What are the main barriers to democratic, inclusive, transparent, and consensus-oriented reforms? And what interventions can be adopted for good electoral practice? We based on 2 theoretical frameworks, which is the institutional framework, like the EMB, outside the EMB, and also the political economy of the place. How does poverty affect electoral outcomes? So we talked about the principles of and barriers to electoral reforms. We saw that in the case of Nigeria, the principles underpinning electoral reforms would be basically on democracy, which is the foundation upon which all electoral reforms are built. Inclusivity, because some people seem not to be included in the electoral process. Transparency, obviously, of the EMB. Accountability and consensus building among the minority groups. We also saw that there are some barriers that exist, some political barriers, some social barriers. Some people, based on their religion, they don't vote, they want to vote. some institutional barriers that also allows people not to participate in the process. Strategies we think that can overcome these are multi-stakeholder collaborations, capacity building, monitoring and evaluation, and community-based approach. Community-based approach is that we think that involving the traditional rulers in the electoral process would be like a good thing to go. Our main source of data came from the EMB, which is in the case of Nigeria is INEC, the Independent National Electoral Commission, from academic studies and from case studies, which we are going to see subsequently. From our literature review, we saw that there are some challenges in implementing electoral reforms, which we documented in our paper. It's about maintaining public trust, which has been eroded over time in Nigeria from what those data states. Transparency, ability to communicate, and public participation, which has dropped from the data that we showed. We also think that best practices from what my last speaker said could be like a good way to go from what we discovered in the literature review. We use an analytical framework which we are underpinned in 3 areas. We talked about the principle of assessment. We talked about the barrier analysis, and we talked about the intervention evaluation. We think that these were the 3 frameworks that we could be used in the case of Nigeria. We also talked about what are the evaluation principles that underpin that. We talked about also from the principles, we now went down to the principles, the barriers, and intervention in evaluating where we are as a process in this period of 25 years of democratic rule. So when we talked about the case studies we wanted to compare Nigeria with another country. So we talked about an emerging democracy, which in our case is Nigeria, and an established democracy, which in our opinion is South Korea. So we looked at 3 broad areas, which are the electoral reforms, which is the technological reforms that came. In the case of Nigeria, the BVAS in 2023, institutional reforms, which are the legal processes that came through the National Assembly, and some of the superficial, like what are the economic indices that will underpin these electoral reforms. Sorry. So when we looked at South Korea, we used that, what is it that we can learn from South Korea? We saw that they introduced like a mixed proportionate representation. And this reform also meant that there are numerous minority tribes, like in Nigeria, that meant that they were not participating in the electoral process. It allowed voters to cast vote for political parties and for candidates. And then this shift encouraged smaller parties to participate in the electoral process. But in the case of Nigeria, we saw that corruption within the electoral management body and allegations of bias eroded public trust, that many citizens view elections as predetermined events, leading to apathy and disengagement, and violence and intimidation within the electoral process. So when we compared these 2 sides, we saw that Korean reform focused on increasing transparency and accountability in the electoral process. But the Nigerian experience, particularly in 2023 election, highlights the complexities of electoral reforms. The BVAS significantly improved the transparency of the process, which was very elaborate. But however, the election was characterized by logistic issues, voter suppression, and violence. So we think that if we can use the South Korean case to model a Nigerian case, we could say that one of the positives that could come out is legal reforms and establishing transparency in the process. In the case of Nigeria, we saw that the BVAS was a good thing that helped the process to be appreciated. People really saw that there was a change. But in the negative that came out from 2023 was that there was voter suppression and violence. And this mixed outcome suggests that while technology reforms can enhance the electoral process, must be accompanied by broader institutional and legal reforms to be effective. And that we stated that in our book. So from the 3 research questions that we talked about, and what principles should underpin the electoral reform process, in our opinion, the independence of the electoral management system, which we'll talk about in the WASTE report, the transparency of the process, accountability, inclusivity, and public participation. That we think that are what this research question number 1 will outline. Research question number 2, what are the main barriers to democratic inclusive, transparent, and consensus-oriented electoral reforms. We think that minimal political interference will be like one of the things that will be a barrier. Political interference, corruption in the process, a lack of political will. That is one process that we'll discuss more in the Nigerian context. Public apathy and distrust, insufficient resources. For question number 3, what interventions can be adopted to ensure good electoral process? Capacity building for CSOs, the EMBs, the political parties, and by extension, the electorate. Technology utilization will democratize the space because we can see what technology can do. Multi-stakeholder participation and regular monitoring and evaluation. We think that interventions that can be adopted. So the key findings will balance the two sides of the divide would mean that independence of the electoral institution is very important, the EMB. Public engagement, civil society involvement is key. Effective use of technology, the political will, I will always state that within the Nigerian context, the ability for people to do the right thing and addressing corruption. So the Justice Wales report becomes like a real framework for us to go, and it has addressed lots of things, but I'll just pick 3, which is insulating the INEC from political interference. That is a very key problem in Nigeria. Creation of Electoral Offense Commission, and then reforming the electoral process for resolving disputes, but ensuring that case adjudication are done before people are sworn in. That way, people can actually focus on governance. So in closing, my recommendation is this. For policymakers and practitioners, especially our great host, WFD and the Electoral Interactivity Group. In the Nigerian context, we say that strengthening electoral institutions, promoting public awareness and engagement, leveraging on technology, in the case of Nigeria, electronic voting, building political will, first to pass diaspora voting and early voting bills, combating corruption. So in introducing the diaspora bill, we will say that it will empower millions of Nigerians. Like I'm talking to you from Canada, I can vote for me. I don't need to go to Nigeria to vote, but that is not the case right now. And early voting, which means that those that are going to work in the electoral body, the military and all the rest, can also come in to the voting cycle because they don't vote on election day. And those votes should have a right to vote. So we think that introducing the diaspora voting bill and early voting will be like a good way to go. I want to thank you for listening to me, and have a good day. Thank you very much.
Thank you very much for that very interesting presentation. Lots to unpack there. There's a lot of information in the paper as well, so I can recommend everybody to look at it. It's online already. We'll move on to the 3rd case study. We're moving all across the world and Europe, and we're moving to Lithuania. Laura, I'm sorry, I'm not going to try to say your last name because I'm going to butcher it horribly, but the floor is all yours and take it away.
Thanks a lot. Oh, sorry, my surname is quite difficult also in Lithuanian language, so it's okay. So firstly, thank you for having me here. It's a huge pleasure and honor. And yeah, today I want us to tell something about electoral reforms in Lithuania in the past decade. Firstly, what I want to say that the stability of the electoral system is a fundamental principle of democratic governments, but every country must adapt to changing political, legal, and technological realities. So over the last decade, Lithuania has implemented significant electoral reforms to straighten the legal framework, ensure transparency in the electoral process, and adapt to modern challenges. Some of the most important changes have been the adoption of the electoral code, about which we discussed about 10 years, the debate of the legalization of online voting. We discussed and discuss right now more than 15 years, I guess. The review of constituency boundaries, the electoral threshold, the tightening of campaign finance, and the lowering of the candidacy age. So one of the most significant developments of the last decade was the adoption of the Electoral Code in 2022. And this legislation consolidated the previously separate electoral laws in a single codified system, including laws on elections to the parliament, the presidency, municipal councils, and the European Parliament, as well as the operation of the Central Election Commission. And this has led to the unification of procedures for organizing the various elections and increased transparency. In addition to this structural change, significant innovations have been introduced, for instance, limiting mayors to 3 terms in office, the exclusion of negative political advertising, the expansion of early voting sites, the extension of voting days, and new mechanisms for regulating political advertising, and etc., and etc. And the Electoral Code established that political advertising can only be commissioned through official campaigners, not through third parties, for instance. Additionally, the period of prohibition for election agitation was significantly reduced from 30 hours to 7 hours, before elections. Another innovation concerned electoral deposits. The amount of the electoral deposit was reduced for candidates holding incompatible positions to encourage greater participation in the elections. But despite the desire to unify and stabilize the procedures for organizing elections, it became clear after the first elections under the new code that certain provisions were not sufficiently clear. In the 2023 municipal council and mayor elections, a number of gaps were identified, and the first proposal for amendments to the code were tabled 6 months later. However, amending the electoral code is a complex process, and it is included in the list of constitutional laws and requires 3/5 majority of MPs. So we have a lot of codes, but this is only one constitutional code, a constitutional legal act. Moreover, the electoral code cannot be amended during the except when necessary to implement the requirements of the Constitutional Court or European Union legislation. Another topical issue that has been debated for more than a decade, as I mentioned, is online voting. Although Estonia introduced the system in 2005, Lithuania has not yet found the political will to implement it. Of course, we had earlier than Estonians opportunities. We had electronic voter list and other things, but we see the geopolitical situation and the nightmare next door. So in 2014, the first draft law on online voting was submitted to the parliament, but it was rejected. And 4 years later, the Ministry of Justice drafted a law on online voting, but this too was not supported. And few years later, in 2020, amendments to the new law were adopted to allow online voting for self-isolated voters, but the system was never established because 4 months before elections to establish such a system, it's impossible, in my view. So a study carried out in 2023 identified two main risks. So possible cyber attacks that could discredit elections and the lack of confidentiality of voting data, even with advanced encryption technologies. And while online voting could increase voter turnout and facilitate the voting process, the political will to implement this reform is currently lacking. Maybe some time ago, then we will discuss. Another thing is in 2015, the Constitutional Court ruled the differences in the number of voters between constituencies of up to 20% violate the principle of equal voting rights. So this threshold was therefore reduced to 10%, meaning that as many as 42 single-member constituencies has to be redrawn ahead of the 2016 parliamentary elections. So this change was important to ensure equal representation of voters. But on the other hand, it also increased the number of constituencies made up of more than one municipality, with an increasing number of constituencies now covering 2, 3, or even 4 municipalities. Another question is political campaign financing. So the regulation of political campaign financing has also been tightened, and new rules introduced, for instance, in 2019 and later, have limited the size of donations and introduced stricter regulation of campaign spending. Candidates and parties were banned from receiving cash donations and were obliged to return unexplained donations to the state budget. In addition, the accounting of campaign expenditure has been tightened. For instance, if a campaigner is found to have underdeclared part of the expenditure, so they may be obliged to pay the same amount to the state budget. Also, if a campaigner makes too many commitments, the CEC may decide to limit their campaign expenditure. Again, one question was, of course, related with age limits. So an important aspect of electoral reforms was the lowering of the age limit for candidacy. And until 2022, only people aged 25 and over could run for parliament, but an amendment to the constitution lowered the age limit to 21. The aim was to involve more young people in politics, but some critics of such proposals argued that younger candidates may not have sufficient experience in public administration. Maybe, who knows, maybe they know better, but I think it's a good thing and good idea. So in addition of these changes, reforms have been sought in the structure of electoral administration. One of the most significant aspects was the depolitization of the CEC. And previously, the composition of the CEC consisted of members, half of whom were delegates from political parties, which often raised doubts about the impartiality of the CEC. To this end, the possibility of completely depoliticizing the composition of the CEC was considered, but this initiative did not receive sufficient support. Critics argued that the complete exclusion of political parties from Commission could reduce its accountability and its connection to the democratic process. So overall, the electoral reforms implemented in Lithuania over the last decade have had a significant impact of the transparency and stability of the electoral system. It's no doubt that while some reforms, such as lowering the age limit for candidacy or making campaign finance transparent, have been successfully implemented, others such as legalizing online or internet voting or lowering the electoral threshold still await political will. Maybe future challenges will include integrating technology into the electoral process, increasing voter turnout, and further strengthening democratic institutions. And in light, what I want to note is maybe in light with the electoral principles in the case of Lithuania, when we're talking about Lithuania case, reforms should be prioritized by clear stakeholder consensus, also transparency and inclusiveness, and should be based on strong evidence of need and potential impact. Reforms should also be timely to address emerging challenges, such as ensuring fair representation and adapting to new technologies such as online voting. Only then will reforms strengthen the electoral system without compromising democratic integrity and the whole democracy. But do we have all this now? Yes, political parties cannot change the election code without consensus because it is a constitutional law, and we need 3/5 members consensus. So we have 141 members in the parliament. So yes, the public political scientists, lawyers are involved in the debate when we're talking about changes when we want to change our electoral system. When we discuss about we need proportional electoral system or mixed electoral system, which we have right now. And the reforms are not made just before elections, because our election law doesn't allow this. And but do we have enough transparency, accountability, and finally, are our reforms based on data? Yes and no. Maybe no. We are not. We are on the right track, but there's a room for improvement. So this is my presentation, and thank you a lot for your time and patience. If you have any questions, I will be ready to answer.
Thank you very much for your presentation, for taking us through 10 years of changes in the electoral system of Lithuania in 12 minutes, which is very impressive. We're moving on to our fourth speaker, Victor Pascual, who's talking about a topic that's very close to my heart. When I was a very young legislative lawyer, I drafted the constitutional change in the Netherlands that allowed for more voting rights for people with intellectual and mental disabilities. So I was very happy to read your paper, and I'll give you the floor to talk about your case study from Spain.
Thank you very much, Leontine. My name is Victor Pascual. It's been a pleasure for me to be here. Thanks for having me in this interesting debate conference. So yes, as Leontine has said, I'm going to speak about a very specific issue about the rights to vote of persons with intellectual disability. And I'm going to share a short presentation. So let me check. Okay. I think you can read it. Yes, you can see it. Okay. So yes, I work as a teacher of public international law and human rights in the University of Comillas in Madrid. And also I have many papers with regard to political rights and election observation, and also about the right to vote of persons with disabilities. Now, my paper is about in Spain improving the electoral system by recognizing the right to vote for persons with intellectual disabilities. As we all know, the United Nations Convention on the Right of Persons with Disabilities was a paradigm shift in the approach of the right of persons with disabilities, because this convention proclaimed the right to political participation to all persons with any kind of disabilities. In Spain, before 2018, nearly 100,000 citizens were deprived of the right to vote because of having some kind of intellectual disabilities or mental illness or cognitive impairment. But the situation changed with the 2018 reform, which allowed all people with disabilities without any exception to exercise the right to vote. First, before diving into the situation in Spain, I just want to give you a very brief overview about the situation in Europe and in the United States, in which, as a summary, I can say that many persons with disability have the right to vote restricted by many legal frameworks in many countries today. For example, in the United States, the regulation depends on the state. So some states establish some limitations and restrictions, while others deny the right to vote to idiots or those persons under guardianship. No? In Europe, most countries have ratified the UN Convention, but the principle of universal suffrage is not consistently applied. For example, in the European Union, since 2014, 6 member states have abolished restrictions on the right to vote for people with intellectual disabilities, but however, there are still around 800,000 people from 16 member states deprived of the right to vote. So this is a very universal issue, the kind of restrictions on the right to vote of persons with intellectual disabilities. So for Spain, going back to the case of Spain, after Spanish ratification of the UN Convention on the Rights of Persons with Disability, Spain was obliged to reform the electoral law to guarantee the right to vote of all persons with intellectual disabilities. So it was a need for reform. So this situation led to the reform of Article 3 of the Organic Law on the General Electoral Regime. Here you can see the previous situation before 2018, Article 3 of the election law, depriving the right to vote to all persons declared incapable by a final court decision or admitted to a psychiatric hospital with judicial authorization. I'm going to share with you the wording of Article 3 before the reform. Here you can see that Article 3 said that the following persons do not have the right to vote. And you can see sentenced by a final court judgment to the principal or accessory penalty of deprivation of the right to vote. And in red, you can see the former wording of the article. Even didn't have the right to vote, the person declared incapable by virtue of a final judicial judgment, and the persons admitted to a psychiatric hospital with judicial authorization, provided that the authorization, the judge expressly declares that they were incapable of exercising the right to vote. What happened after the reform? With the reform, the article changed to this wording that you can see in the slide. So the action taken by the Spanish government and the Spanish parliament was to remove section or letters B and C of section 1 of Article 3. As you can see in red, letter B and C didn't exist from 2018. But also you can see that there was another paragraph included in Article 3. In green, you can read that every person may exercise his or her right to vote actively, consciously, freely, and voluntarily, regardless of the form of communication and with the means of support that he or she requires. So, after the 2018 reform, the Spanish legal system put an end to a democratic deviation that meant that more than 100,000 people were deprived of the right to vote for reasons associated with disability. After 2018, all people with any kind of intellectual or physical or psychosocial disability are entitled to vote, to exercise the right to vote. Okay? So, in general terms, the reform was seen as a positive progress for the Spanish society, for granting the right to vote for more people in our country, but at the same time, this reform resulted in many criticisms and many voices, doctrinal scholars, criticize some issues about this reform, okay? So here you can see a recap of the most important criticisms received by this reform. The first one, the risk of manipulation. There are many concerns about the possible abuses of the will of these persons with intellectual disabilities that are considered more vulnerable. For example, situations of impersonation of their personality in the act of voting. Secondly, the legal framework is ambiguous. It's not very clear. As you could see previously, Section 2 said that the vote must be conscious, free, and voluntary for all people. But the point is that the reform didn't see anything about how to guarantee in practice this conscious, free, and voluntary vote for persons with severe intellectual disabilities, for persons that even don't have any kind of political self-determination, or even don't know anything about a minimum knowledge about the legal or electoral system. So we have to debate about that because it's a very controversial issue in Spain after the reform. The third question, with some criticisms and doubts, is about the lack of competencies of the presidents of the polling station to intervene in case of detecting some kind of infractions to the freedom of suffrage. And finally, another important issue is that even we have abandoned Spanish jurisprudence that support restrictions on the right to vote only exceptionally when there is a direct and conclusive proof that the person lacks all reason and sense about the act of voting. So this kind of doubts are emerging because related mainly for those people with severe intellectual disabilities, with the people that don't have any kind of reason and sense about the act of voting. Okay, so related to the jurisprudence, the Spanish jurisprudence, give a very quick remark about the international jurisprudence on the right to vote for persons with with intellectual disabilities. In the Inter-American system, the American Convention on Human Rights allows for legal restrictions on the right to vote based on civil or mental capacity. If we move to the European system, the European Charter of Human Rights recognizes that the state may establish certain requirements for the exercise of the right to vote. But it's true that since the Alajowski's case that I mentioned here, that the automatic deprivation of the right to vote is not allowed. It's contrary to Article 3 of the European Convention of Human Rights, the protocol of the European Convention of Human Rights, okay? But recently in Spain, and I'm trying to go very quickly to respect my time, recently, the European Charter of Human Rights in May 2021 ruled in favor of Spain in a case concerning the deprivation of the right to vote of a legally incapacitated person. So even 3 years after the reform in Spain, the reasoning of the court was that the limitation, the restrictions imposed concerning the right to vote were not based on a discriminatory basis, but on the strict and objective verification of the lack of a minimum capacity for that person regarding political and electoral matters. And the European Charter of Human Rights also reinforced this decision because, as you know, in the European system, these restrictions can fall within the margin of appreciation of the states to regulate the right to vote. Okay, so this was the judgment, the statement of the European Charter of Human Rights. It's true that in that case, the European Charter of Human Rights was playing with all rules. So we have to see what happened with the new rules we have in Spain. But as you can see, the reaction of the United Nations Committee on the Rights of Persons with Disability and the Special Rapporteur on that topic considered that this judgment was a disappointing setback with regard to the rights of persons with intellectual disabilities. Okay, so to those people that consider that this reform can jeopardize the integrity of the Spanish electoral system, what I do in my paper is to share some proposals to strengthen the integrity of the electoral process.
You have one more minute, Victor.
Yes, okay, thank you very much. So 4 ideas. First one, to establish the mandatory secret ballot in the booth to guarantee the secrecy of the vote and avoid possible risk of family voting, social pressures, and potential abuses against, for example, persons with intellectual disabilities. Because in Spain, to vote in the booth is not mandatory. So I think it's a very important reform to be done. Secondly, to remove the practice of sending candidate ballot to voters' home, which allow many people to prepare from home and can promote voter abuse and manipulation, specifically for persons with intellectual disability. Third step and third proposal, to establish a specific assisted voting procedure available to all persons with any type of disability who request it and under the supervision of the president of the polling station. And finally, the last proposal is to empower the president of the polling station as the authority in the polling station to ensure the observance of the law and to ensure the freedom of voters, to give more powers to these presidents in order that they have the possibility to grant this assisted voting procedure or not in cases of possible abuses to the will of these people, not only the people with intellectual disabilities, but all people that can vote without the required freedom to exercise adequately the right to vote. So these are my conclusions, but finally, very quickly, this reform is considered a progress for the electoral Spanish system, of course, but it's true that there are some issues that have to be reformed in order to protect the integrity of the Spanish electoral process. Thank you very much, and at your disposal, you have any questions. Thank you.
Thank you very much for yet another very interesting presentation on a very important topic. I am handing the floor over to our last speaker of this panel, who's going to speak on the findings of a very large observer mission during the European Parliament elections. Armin, I'm giving you the floor.
Thank you, Leontine, and welcome everyone. It's a pleasure to present to you about the paper, What Remains to be Done, Thinking Through Reforms of the European Parliament Elections. This is a paper I wrote together with Markus Pollack, who is also present here. And I've also seen that a number of experts who have been working with Election Watch EU over the years are also present during this conference. Now, we as Election Watch EU, we are international election observers who brought the good practice back to our own countries in the European Union. For your information, we conducted the second election assessment mission of the 2024 European Parliament elections, together with 77 election observers and 10 like-minded organizations. And that's the second time after the 2019 elections, and a report has been issued with 21 recommendations and 19 good practice examples. And that's the whole idea about this presentation, to see good practice examples of what we gathered from the different member states as a stimulus for positive change in electoral reforms, because we have seen that the electoral reforms at the European level have been staggered and are still pending, like the 2018 reforms, which are still halted by Spain, or the 2022 proposal by the European Parliament, which was far-reaching. Just some few facts. The European Parliament elections are the biggest elections worldwide of a multinational parliament. So only the Indian elections are big in terms of numbers of voters. It's still 27 separate elections conducted by the national election management bodies across the 27 EU member states. And as said, there is a big proposal on the table brought by the European Parliament, but very ambitious, including the Spitzenkandidaten proposal, the transnational lists, but then also one single election day quota for women representation, voting with 16, electronic voting, postal voting for out-of-country voters, etc. What also needs to be said, this European Union is still integrating and is still successfully integrating in the area of elections. And we see that especially when we have the case of emerging threats, like in the digital space. We had a voluntary self-regulatory framework regarding online platforms and social media networks in the 2019 elections. And since the transparency mechanisms were not sufficient to the taste of the European Commission and the EU, it came up with a whole new legal framework surrounding the online space, not only the Digital Services Act, Digital Market Act, but then also the Transparency and Targeting of Political Advertising Regulation, as well as European Freedom of the Media Act, Anti-SLAPP Regulation, and now the latest, the AI Act, which is a horizontal legislation, and now secondary legislation needs to be followed up to also provide guidance when it comes to elections. If we look at the reform process so far, 50 years back, the EU brought up this European Electoral Act 1976, which was providing for the first time direct elections to the European Parliament and to the Common European Assembly. So if you look at the table here, you see that we had 10 elections so far. You also see that in 1979, the first election had only 9 member states, and now it's 27, one less than last time since the Brexit. And now we have some 355 million voters in these elections. The first amendment which happened was in 2002, which brought up the generalization of proportional representation, and also the abolition of the dual mandate, meaning a member of the national parliament could not at the same time serve as a European member of parliament. So we also see a strengthening of the European Parliament along with the Lisbon Treaty in 2007, especially when it comes to the role of appointing the Commission President. Also, the interpretation of what is the member of the European Parliament. It's not a representative of the state, but more a representative of union citizens. And we pictured that in our paper, and this idea came from Marcus Pollack, to draw on Claude Lévi-Strauss and Vincent Pouliot's work, that it can be understood as a bricolage. Yeah, so it's a very supranational way of integrating in and reforming the European electoral legal framework. Now, what we have seen in this respect, or what are the advances? First, we have seen this European Cooperation Network on Elections. So it's basically a coordinating and cooperating body called by the Secretariat, which is the European Commission, and representatives of all 27 EU member states are exchanging ideas about how to improve elections, how to cooperate, and how to exchange data about, for example, mobile EU citizens, yeah, to avoid that you have double registrations, and also the Commission provides a crypto tool for that effect. Then we see there's a staggered approach that member states are learning from each other. They are slow adapters. You know, we see always that there are some member states are more conservative than others. For example, we have seen voting with 16, like Austria, my own country, Malta, have been leading the path on that. The EU Parliament is always trying to push the voting age down to 16. So far, only Belgium and Germany have followed for the European Parliament elections. And then we see, as I mentioned, this quick legislative action, if there is political will, and it can be also far-reaching, like this Transparency and Targeting of Political Advertising Act, which is now in full force, and we'll see quite a substantive control and accountability on the side of the Meta and the alphabets, etc. Now, where are the constraints? Yeah, and here we see that the EU is still caught up in this framework that this kind of legislation needs the agreement of all member states. Yeah, so we have a blockage, and compromise is sometimes difficult. We see that, for example, when it comes to the amendment of the legislation regarding political party and campaign finance legislation. So this is still stalled in the European Parliament because there's no compromise found among member states and political parties. Then there is sometimes the reforms are too big or too ambitious, yeah, and everything is put into a package like Spitzenkandidaten, transnational lists, quota for women, voting with 16, and this is undigestible for member states, and it doesn't sail through the institutions first, and second, through the Council of the European Union, where the member states need to agree all to the reforms. Now, what we see is also that more often sovereignty succeeds over integration. Yeah, like small member states fear that transnational lists could reduce their power in the European Parliament. Big big member states feel that a Spitzenkandidat process could also lower their powers to determine who is the leadership of the European Commission and the European institutions. Now, what we suggest is more of a bottom-up approach where we collect good practices in electoral reforms from the member states and think that could be a stimulus for positive change in other member states and produce altogether electoral reforms at the European level and in the member state level. If you want to look more in detail about the different examples, you find them in our report. It's all together 19. And I only want to mention 3 here and take out 3 here, and you can look up the others. One is what's very close to our heart is the promotion and acknowledgement of election observers, not only international observers, but also citizen election observers. So we say, okay, there's a challenge because only 9 EU member states provide legislation accreditation for election observers within their member states. Yeah, while the EU is promoting election observation and democracy abroad, worldwide, we don't have the same standards at home. So the good practice is, for example, in Finland, which recognizes observers on the basis of adherence to principles of impartial and professional observation, like the Declaration of Principles. And we recommend that all countries to include legal provisions for international and citizen election observers and provide accreditation procedures. And the Commission has already taken up this proposal and came up with the recommendations ahead of the 2024 elections coming up and strengthening the role of observers in the process. So we have also, as Election Watch EU, a very good relation with the Commission on that. Second example, women participation in politics and elections. The challenge has been that electable and political appointment positions in EU member states remain the areas with the widest gender gap. We highlight the example of Luxembourg, where public funding is conditional to equal gender nominations. Non-compliance results in the reduction of funding by a quarter of each missing candidate of the other gender. So it means, okay, there's an incentive to have equal representation, otherwise there's a penalty that you get less money. So we recommend that—
One more minute.
Perfect. Thank you, Leontine. And so the recommendation is that other countries, especially countries where there is a very limited representation of members in the European Parliament, of women especially, and we have even one member state with no women in the European members in the European Parliament, that this is brought throughout and is in line with international standard like the CEDA. Last example which I bring is the example from Austria to publish electoral results broken down to the polling station level. And we are also proud as Election Watch EU that the European Parliament altered the displayed results on its website, since we found some discrepancy with the numbers from Spain in this respect. So we also think a level of transparency and a higher level of transparency can be pursued in this respect, and it would also help to look at good practices. Now, final word, we think observers can also make a difference in the observed state, because we can provide positive feedback in a very visible way, and not only criticize practices in member states, for other states that they can learn from the solutions found in countries like Estonia, with e-voting, for example, other countries like Spain with voting for persons with disabilities, and then for the observers themselves, that they are not just seen as critics, but also as catalysts for positive change. I leave it with that, and I'm happy to answer any questions. You will find here our election assessment mission report as well. Thank you.
Thank you very much. It is very interesting and very important work what you do with your observation of all these countries, and it's I can recommend everybody to work with Armin and Marcus to get this done in the next couple of years as well. That is a very large amount of information that was given to us by five very interesting speakers. I'm happy that I have 2 people that are going to help me with giving some comments on the papers and the presentations. And I'm first giving the floor to Robert.
All right, thank you. It's really a pleasure to read all of these papers. I have little experience understanding the politics of these individual countries, but I am hopeful that I can play some sort of a role in helping frame these papers in a broader way to try to bring out what I see as some common themes, or some themes that might serve to bring up theoretical issues. Let me start with the Lithuania paper. I also will not try to pronounce your last name. Here are the things that I found most interesting in this paper that I'd like to hear more about, sort of from a comparative perspective. First, you frame the concept of online voting as a matter of competition, that Lithuanians see themselves as wanting to be innovators, or as competing with other countries to be the innovators. This is an interesting way to frame the issue, and I'd like to hear more. The discussion of electoral boundaries in the paper is also quite interesting. The difference in magnitude from one district to the next actually seems quite large to me. In the US, for instance, there's virtually no deviation in population from one district to the next. Lithuania has perhaps maximized the likelihood of keeping communities of interest together, which is also an important goal of trying not to divide municipalities if possible. So there are some interesting trade-offs here that I think lead one to ask a little bit about what the mandate is for district boundaries, to think a little bit about the role that political parties might play in drawing districts for their own purposes, or to think about the appropriate balance of districts and at-large representatives. What's also missing here that I think is consequential is talking a little bit about the frequency with which districts are drawn. Certainly a disparity in district size will become inevitable if the population moves about and districts are not redrawn frequently. So that's another important thing to think about there. The campaign finance system, the caps that you discussed, seem in line with many other countries. I note as well that the disclosure threshold is also pegged to the monthly wage, which is something that not that many European countries have done, but that has been done, I think, by some of Lithuania's neighbors in recent years. And to get to the conclusion, I think the big question here that echoes in some of the other papers as well, you claim at the end of the paper that stability is a matter of popular trust. On one level, that's certainly correct. It's important for the public to understand what the electoral rules are. But I did a little bit of Googling, and public trust in government in Lithuania is actually quite low, ahead only of Latvia, Greece, and Slovakia. So it'd be interesting to think more about the relationship between stability and public trust, particularly in countries where trust is a little bit low. Should we perhaps, demote stability as a political goal? Okay, moving on to the Spain paper. I found this just completely fascinating. There are a lot of issues that come. I understand that this paper is specifically about Spain, but since you do bring in comparisons of a few other countries and comparisons of the American states, there are some fascinating comparative questions here. You note that many countries have laws that I think you would deem to be more progressive or more inclusive than others. It's interesting to think about how those might have come about. In the case of many of these countries, it seems like it's possibly an oversight, right? States or countries just simply didn't think to make laws regarding intellectual disabilities, whereas others may have had a very deliberative process of developing these laws. So it'd be interesting to think about how national differences emerge, whether they're a function of goals of individual legislators, whether they're the consequence of reasoned discussion, or perhaps just accident. I was curious as well about analogies. Essentially, the question here is whether voting is a right, a privilege, or a responsibility. So it'd be interesting to think about other types of political engagement, jury service, taxes, other types of political expression altogether. I also did not get a sense from the paper about what the risks really are. I understand that one concern here, sort of a worst case scenario, is that voters will be manipulated potentially by family members or others who might vote on their behalf. I don't know how likely this might be, and I think one could read some of the recommendations and conclude that you're placing a higher burden on the individuals with disabilities than on people without them. That is, it seems to me that as you frame it, there's actually less of an expectation that people with disabilities will vote by mail than is the case for others. I was also curious about the political dimension to these discussions. In the United States, one thing that came up in the last election was discussions of nursing homes. There were allegations by some conservative politicians that nursing home employees might vote on behalf of their residents, that this was a form of fraud to look out for. So this became a contentious issue in the election. I don't know if this is your experience in Spain or elsewhere. And finally, there's a larger story here about proxy voting and how we might think about it that perhaps comes from from your paper. And then finally, the EU paper. I think the trust issue here comes up as well. It seems to me, you certainly know this issue better than I do, but that public faith in EU elections varies substantially from one country to the next. So it'd be interesting to think a little bit about the role that trust plays in the individual nations. I really like the bricolage framing that you've given, that in many ways, it's countries at times have limited ability to make changes, that many changes happen incrementally, often for idiosyncratic reasons of the countries in question. So I think that's something that you can build upon, but it really leads one to I think discussions about how to organize the examples that you have. This table that you have on page 11, you argue that these are all impactful, good practice examples. I have no doubt that they are, but just saying that they are doesn't make it so. It would be interesting to hear more about dimensions, about differences between these different types of reforms, why in fact they constitute good practice, or how we might categorize the different types of reforms. And finally, to the question of sovereignty, I think there are two ways to think about sovereignty here, and I'd be interested in hearing more about those. One might be a simple pushback by nations to say, we're going to do things our way and nobody's going to tell us what to do. That's a sort of contentless argument about sovereignty. It doesn't argue that a particular voting rule is valuable, for itself, right? It says more, we're not going to change this just because. On the other hand, many voting rules or practices might be a matter of national culture, that nations may be proud of a certain thing that they are doing. To tie us back to the claim I extracted, rightly or wrongly, from the Lithuania paper about nations being proud of their efforts to establish online voting, or to think about your discussion of the voting age in these different countries. Is sovereignty here a matter of the practice fitting national culture, or is it just a sort of rejection of the idea that somebody will impose rules upon them? So those are my comments. I think there's some interesting themes that percolate through all of these papers, and hopefully these help you to think a little bit more about what your papers have in common.
Thank you very much, Robert, for these very useful comments for the papers. I'm giving the floor to Toby for the other two papers that haven't been discussed yet.
Thanks, Leontine. And just to echo Robert, that I enjoyed all the presentations and all the papers immensely. So many overlaps and so many sort of great ideas. So I focus on the two others. So looking at Edward's paper and Edward and colleagues first. It was, I thought it was a really, really rich paper with so many, sort of wonderful ideas and sort of rich materials that are brought into this. I think there's much more scope for research looking at Nigerian electoral reform. I think there's many, many lessons to be kind of learned from it. I think the main thing I'd probably focus on pushing you towards is narrowing the scope. So the conference has been really the key thing we've been trying to push in a way is the idea of democratic principles, and your paper's brimming with principles. and possibly brimming with too many research questions as well. So I think my main steer would be to sort of narrow down the focus. I think you could see how, for example, a paper could set out a smaller number of principles, so they could be like the ones in the Genti framework. There's 6 principles that are also going to be in the book introduction, or they could be those that are then revised in light of the materials that you've got, or they could be like your own principles that you want to kind of set out. But I think just having a smaller set of principles from the start would be really helpful, and narrowing the research questions as well in terms of it could be, for example, looking at the extent to which those principles were followed. So I mean, there's so many ways you could go, but I would suggest, setting out those principles and then thinking maybe about a particular reform in Nigeria which was passed, and considering and assessing the extent to which those principles were followed. So the one that stood out for me in the paper was the smart car reader, because you say that this was in 2015 was a really important moment of change, and this had various other effects. So it'd be really interesting to see, for example, if you to go back through the archives, to what extent were political parties on board with this? Was there a degree of consensus? Otherwise, I think the South Korean comparison is helpful, but I just worry that there's probably too much you're trying to cover in the paper adequately. This could be a book, and maybe should be a book, because you clearly got the ideas and the materials to make it. But I think for a paper, I'd focus on one particular reform in more detail. And then on the Polish case, and again, thank you so much for the presentation. I learned lots from that. Very happy to kind of provide some more detailed comments on a paper once you kind of get there. And yeah, I mean, there's so many fascinating aspects to this, because there really are so few studies that actually go back and look at electoral reforms against these principles. That's kind of why the conference is here. And I think focusing in on the sort of evidence dimension pulls apart so many great insights. The fact that timeliness was an issue for example. So I think strong encouragement, carry on. It's like a really important study. I think things that maybe would be interesting when you got more than 10 minutes to be able to present it, to kind of consider and touch on, is you talk about influence. So how influential was a piece of research? So obviously in the writing and the analysis, then the question that kind of comes up is, how do you measure influence? Is it the number of citations? Is it sort of textual references? Do you need interviews to kind of make clear that that was the piece of evidence that was followed or was not followed? I think a really interesting question in there is, which is the best source of evidence? So normatively speaking, what should the policymakers be following? Should they be following academic evidence? I'm an academic. I like to think people would listen to us and to me, and academics would say, well, our research is really important because it's kind of systematic, or it has lots of data, or something like that. But then there's other types of evidence, as you point out, that maybe have a different type of normative value. So international standards, they have value in terms of the agreements or binding agreements between countries about what is good or what is bad. So the Venice Commission codes there as well. And then I think what would be really interesting to pull out in the findings further in the analysis is, well, when you've got some really strong evidence, whether it's academic or principles, was it followed? And if it was not followed, what then are the sort of barriers to that? Is it just kind of blazon partisan interest, or is it understanding? Is it something a bit more nuanced there? So yeah, lots to build on, but really, really fascinating paper. So thank you for that.